Good afternoon. My name is Ana Paulina Gomez. I am Chief Counsel with the Pennsylvania Health Insurance Exchange Authority and also proud member of the PBA. Thank you for joining us for this Ethics Lunch and Learn brought to you by the PBA's Government Lawyers Committee and the Administrative Law Section. Today, Mary Fox, the Executive Director of the Pennsylvania Ethics Commission, and Julie Caravan, Assistant Counsel, will talk to us about ethics for government attorneys, a very, very timely topic. If you have any questions, please direct them to me via chat, and we will save the last 10 minutes or so for questions and answers. I know everyone is eager to hear about ethics, so without further delay, please welcome Mary and Julie. Thank you.
Thank you, Ana Paulina.
Thank you.
It's great to be here. We had a list actually of the attendees. I don't think it was the most up-to-date list, but we did get a list last week of who is coming to this, and so many familiar names and faces. We're always excited to talk about ethics, but also really excited that we know so many of you that are on the call today. I've had the opportunity and the privilege to work with many of the people who I saw were attending today, so I'm really glad to be here. I also think some people are repeat attendees for some of our ethics training, so we'll try and mix it up a little bit with regard to this material to keep it interesting. So we're going to talk about the Ethics Act. The goals that I have for the training today is, if you aren't already familiar with the Ethics Commission and the Ethics Act, I want you to be familiar with the fact that we're here and we exist and this law exists. I also want you to have a really kind of a high-level understanding of what the Ethics Act what the topics is, what it deals with, what we do. So I want you to have a high level view of that. We couldn't get through the whole Ethics Act and the Commission's regs in 1 hour. So we're really just going to touch on some of the high points. And then the third thing I want you guys to know, especially since you're lawyers and especially since you're advising clients, I want you to know what to do if you or a client runs into a sticky situation, how you guys can handle that and feel confident moving forward. But this training, we call it the Ethics Act, or a short guide to keeping your clients out of the newspapers. Real quick before I move on, I just want to call out one of our attendees today. Many of you may have had the fortunate experience of working with Jeff Frankenberger. He was our Deputy Executive Director here at the State Ethics Commission. He had served here for many, many years. He left us about a year ago to move to New Jersey with his wife and little daughter, Rowan, but he's joining us today. And he's going to see, as we go through this, a lot of the material started with him. And I've taken it and Frankensteined it and made it my own. But he's the source of a lot of this information. Just a really great guy. So Jeff, glad you could join us today. All right. So I'm going to start with a question, as I always do with this training. Do you trust your government? And so I want you to raise your hand or say yes in the chat if you always trust your government to do the right thing. All right. Okay, Jeff trusts the Ethics Commission, and we get a big fat no. People don't always trust their government. Raise your hand if you, or give me a comment if you never trust your government to do the right thing. I usually have some skeptics in the audience about this. All right. And why don't you let us know if you usually trust your government to do the right thing? All right, so I'm not getting any feedback, but I will say that when I ask this question, here we go, people are saying yes, they usually trust their government to do the right thing. We ask this question in a lot of our presentations. We want to see sort of how the audience feels about trusting government. most people, including me, fall within, I usually trust the government to do the right thing. I don't know if you guys have ever heard of the Pew Research Center. It's like a think tank that asks questions of people in the United States and elsewhere about various different topics. They have conducted what's called a national election study since 1958. And as part of that study, they've been asking this question of Americans: do you trust your government? They started doing this in 1958. And when they started asking the question, about 3/4 of Americans trusted the federal government to do the right thing almost always or most of the time. So there was a pretty high level of trust in government when they started asking these questions. And they do it, I think, every 2 years. Just before I got on the presentation, I checked for 2024, and they have statistics. And 22% of Americans said they trusted their government in Washington to do what is right, just about always or most of the time. So there's been a huge downslope in trusting government since 1958 until today. The good news is, last year, only 17% of Americans said they trusted their government to do the right thing all the time or almost all the time. So we've gone from 17 to 22 in the last year. Who knows what's going to happen going forward? But I sort of like to bring up these statistics just to sort of underscore why we exist and what we do here. Some other interesting statistics: 65% of adults say they believe that all or most people who seek office at the local, state, or federal level do it to serve their own personal interests. And only 21% say that they believe that all or most people who run for office do it to serve their communities. Now, I know that the government lawyers that are on this call, or the solicitors who are on this call, or the clients that they represent, we all do this work because we want to serve, we want to give back, but that's not always necessarily the case. So this is why we exist. So our core mission is laid out right at the beginning of the Ethics Act, and it says the Pennsylvania State Ethics Commission's core mission and guiding principle is that public office is a public trust, and any effort to realize personal financial gain other than compensation provided for by law. We are allowed to be paid for the work that we do, but any effort to realize personal financial gain through one's public office is a violation of that trust. So we're really looking at conflicts between someone's personal interest and the interest of the public. A couple things I want to point out to you. The first one is public trust. Everything that we deal with here, we're keeping in mind is that what we're doing furthering the public trust. So kind of keep that in mind as a theme as we go through this. And the other term I want to point out is personal financial gain, because if there's not money involved and somebody's not trying to get money or getting money, personally, probably not going to be something that we're able to take a look at here at the Commission. All right. So you may be asking yourself, who do we have jurisdiction over? So who's subject to this law? There's really two big buckets of people. The first are public officials, and those are people who are elected to any public position. So the governor, the senators, our representatives, county commissioners, borough council members, township supervisors, commissioners. All of those folks are considered public officials, which means that they're subject to our law. Also, if someone's an appointed official in the executive, legislative, or judicial branch of the Commonwealth or any political subdivision thereof, take out judicial branch, because there's been litigation, or there's been case law removing the judiciary from our jurisdiction. But this also is going to include people like our cabinet secretaries. They're appointed. They're going to be considered public officials. It can also be like authority board members, for example, that are appointed to serve on an authority board. They're going to be considered public officials as well. So that's our smaller bucket of people. There are some carve-outs. For example, if someone serves on a board and they can only make recommendations, they can't actually take action, not going to be considered public officials. That can sometimes look like planning commission members. If their planning commission can't actually take action, they just advise. They're not going to be public officials. So That's the first bucket. The second bucket are our public employees, and this is the much larger bucket of people. These are going to be anybody employed by the Commonwealth or a political subdivision who is responsible for taking or recommending official action of a non-ministerial nature with regard to any one of these 5 bullets. Basically, what this means is if you're employed by a government, by state or local government, and you can make decisions that about how to spend money. You can make decisions about how that have a financial impact on somebody else. You're probably going to be considered a public employee, and then that means you're going to be subject to the Ethics Act. We have actually looked at many positions across the state over the almost 50 years that the Ethics Commission's been in existence. So if you have a person that you represent, or it just comes up that you're wondering if someone's subject to our law, give us a call and talk through it with us, because odds are good we've looked at their position in the past and we can help guide you through it. What matters is not their title. What matters is what they can actually do. So we'll look through that with you and help you sort through that. So those are the 2 big buckets. We think that there's about 160,000 people in Pennsylvania that are subject to this law that fall within one of those 2 buckets. There's also some provisions that apply to solicitors. And I mention that because I think I have some solicitors on the call today. Solicitors are not subject to the restricted activities provisions of our law for the most part, like the conflict of interest section that we're going to talk about. We don't have jurisdiction over solicitors with regard to them potentially engaging in a conflict of interest under the Ethics Act. However, solicitors are required to file statements of financial interest, and we're going to talk about that towards the end of the presentation. But that section, those filing requirements do apply to you if you're a solicitor. Okay. Let's see, sorry. All right, so we have 3 primary functions. First, we do investigations, and we're going to talk about some of those investigations. We issue advice and opinions, and this is a really important part of the presentation, especially with you guys. It's such an awesome tool that we have available, and we're going to talk about that later. And then we also have the statements of financial interest filing function that the deadline's coming up soon, so we're going to talk about those as well. But first, I want to talk about what we don't have jurisdiction over. We get probably around anywhere from 250 to 400 complaints in a year. We open about 10% of those complaints is what we look at, because most of what comes in is stuff that we don't have any jurisdiction over. So, for example, we can only look at stuff that alleges a violation of the Ethics Act. That means we can't look at stuff like complaints about prison food or maltreatment in prisons. We can't look at complaints that would ordinarily be before, like one of the licensing boards at the state level. We do get complaints in from time to time about people who are licensed by Department of State. We can't deal with neighbors who are getting in fights over personal property and real property. Our jurisdiction is very specific. It has to be an issue that falls within one of the restricted activities within the Ethics Act for us to really get involved. All right, so I'm actually going to hand this over to Julie Karabin. Julie has been with us since November of last year. She is our newest counsel. We're thrilled to have her on board. She's been super quick study with learning about this. She's already had the opportunity to present. So I'm going to hand it over to her so she can tell you a little bit about at least a few of these provisions of the Ethics Act that are not allowed, what people are not allowed to do. So Julie, take it away.
Thanks, Mary. So the first thing that I'm going to talk a little bit about is conflicts of interest. This is actually one of the most frequent violations that we see in terms of restricted activity under our Act. Before I get into specifically what our Act deals with conflicts of interest, I just wanted to distinguish between how attorneys typically think of conflicts of interest, because since there's a lot of attorneys on this call, I think that's helpful. Our conflicts of interest mainly look at The main differences are the type of conflict that we're looking at and the type of relationship that we're looking into. So our act, as you can see on the slide, is focused mostly on financial or pecuniary gain and immediate family members, where attorney rules, as everyone probably knows, is focused more so on the scope of your representation and so how that sort of deals with the client relationship. So a little bit more about our conflict of interest. There's a few main key points. The first one being the use of authority of office or confidential information. So that's some kind of way that you're using your position that someone not in that position wouldn't have the same access to. And then second, there has to be some kind of private pecuniary benefit. So this can look like a couple different things. We actually have case law as well that has shown that it can also be avoidance of a loss of money. So that's another way that you can have a type of conflict, and it's either for the official or employee themselves, a member of their immediate family, or a business that they or their immediate family is associated with. And our definition of immediate family is pretty narrow. It pretty much sticks to just parents, siblings, spouses, that kind of thing. Okay. And then, so a little bit more about sort of all the things that I just talked about. A use of office can be more than just voting at a public meeting. That's kind of the simplest way that that could happen. So if you're associated with a business and there's a proposal that involves that business to be voted on with the township, Mary's going to talk a little bit about how to handle that kind of a situation later in the presentation. But we also have situations where people are using their positions in any kind of other way that would use their office. So an example is one case where the commission found that lobbying for a specific result and approving payments or using governmental resources or accepting any kind of unauthorized payments all have sort of formed bases for violations of the conflict of interest provision under our act. Okay, a little bit more about private pecuniary gain. This is kind of self-explanatory, but this is a required element. So a lot of the times we'll get calls in about people that are doing things that people find to be just generally unethical. And that's not what we do. There has to be some kind of specific pecuniary benefit that can be pointed to. And like I had said before, this can include receipt of money or something else of value, but it can also include use of a governmental resource or an avoidance of an expense or penalty. So that it's sort of like I was saying before, avoiding some kind of pecuniary loss. It can also be seen as a pecuniary benefit. We don't consider any kind of intangible political goodwill as part of what would be considered a pecuniary benefit. There has to be some kind of money amount that can be pointed to in some kind of way. Okay, and a little bit more about the types of people that are covered under immediate family members. So like I said, only a parent, spouse, child, brother, sister is considered immediate family under our act. So technically, if there's a situation involving a cousin, friend, neighbor, just any kind of general close person that doesn't fall under one of those categories, that doesn't fall under our act. Not saying you should do any of those things for any of those kinds of people, but we can't really do anything about it. So there might be other circumstances that would prevent us from doing something with any of those other type of people, but specifically under conflicts of interest, these are the main categories. Okay, and so a business with which associated. So this is defined as any business in which a person or a member of the person's immediate family is a director, officer, owner, employee, or has a financial interest. So this can include both for-profit and nonprofit organizations. Basically, the financial interest part of that is defined as any financial interest in a legal entity engaged in business for profit, which comprises more than 5% of the equity of the business or more than 5% of the assets of the economic interest and indebtedness. So that's kind of a lot. Basically, any kind of financial interest, anything that would sort of lead to that private pecuniary benefit is what we're looking for in terms of a business with which someone's associated.
Julie, if I can just jump in on this
Sure.
particular point. So a business does not necessarily have to be a for-profit business. So for example, you can have a conflict of interest, or your client could have a conflict of interest if, say, that in their public position, they're in a position to vote to award a grant to nonprofits, and they happen to serve on the board of that particular nonprofit. Even though the nonprofit isn't making money, it's still considered a business under the Ethics Act. And there was a lot of litigation about that. It's the Rendell versus State Ethics Commission case, I believe, that went up to the Supreme Court, that where the court did determine that a business is not just for profit. Does my screen look all right?
Yeah.
Okay. All right. Good.
It looks good. It looks good.
All right. Great. Okay.
Okay, and there are a couple exceptions. One of them being ones that have a de minimis economic impact. So basically, this is just a small, like it's a small amount of money. We don't have a set dollar amount necessarily. Our commission has found up to $500 to be de minimis, but that's also not to say that that's sort of a limit or anything by any means. It's just a general guideline where the economic impact is too small for us to really be able to do anything. And then the other sort of main exception is what we refer to as class subclass. So basically, this is either if it affects to the same degree a class consisting of the general public or a subclass consisting of an industry, occupation, or other group. Kind of the way that I like to think of this is if there's a vote to lower taxes for all residents and the supervisor is a resident, they're not going to have a conflict of interest because they're benefiting from that decision because they benefit in the same way that everyone else does. Similarly, if they are voting to lower taxes or something for all resident engineers and their daughter happens to be a resident engineer in the township, this would be under the subclass exception because it's applying to all of the resident engineers the same. They're not voting for their specific family member to get anything additional. Okay, and then the next couple of slides are going to be a few different fact patterns of common ethical issues aside from conflicts of interest. Okay, the first one is nepotism. This one is, I think, pretty common across a lot of different situations. Basically, you can't really be involved in the hiring of any immediate family members. There's a case from our commission that was decided where Commonwealth Court had said that a township supervisor, this is the situation that happened, the township supervisor had lobbied behind the scenes to remove a local nepotism policy so that he could hire his son, but he abstained during the voting process. This was still seen as a violation of the nepotism part of our act because he was doing those things behind the scene that he wouldn't have been able to do unless he was in the position that he was in. So he was using his position to get his son hired.
So the Ethics Act doesn't necessarily prohibit two immediate family members from serving in the same governmental entity, but it does prohibit exactly what Julie said, is one taking action to financially benefit the other.
Okay. The next one that we see a lot is use of government assets. In some of our presentations, we play some of these little videos that we put together. And one that I really like explains this situation. And it's based on a case called Yoder. But the situation basically is that a township supervisor is speaking to one of the other township officials and realizes that there's extra paving materials. And he says, hey, can you just use the rest of that to pave my driveway? And so he does, and that's a situation that isn't allowed because there's not enough for the entire township to get their driveway repaved. And this supervisor only had access to that material through his public position. So again, that's a situation where he's using his position to get that additional benefit. And that's sort of a good example, I think, too, of one of those non-monetary pecuniary benefits where he is using just additional government assets to benefit himself.
Julie, this can extend to more than just things, right? Like this can extend to having maybe for example, directing subordinate employees to do personal work for you while they're getting paid by the taxpayers. That's a problem. We also had a case involving a state level employee who was a surveyor at PennDOT. He had the authority, he had oversight and authority over this equipment, this survey equipment. There was actually the physical equipment, and then there was an IT program that went along with it. He actually requested supplementary employment in order to run a private survey business. He only did it on the nights and weekends, but what he did is he used the equipment in the IT program that belonged to PennDOT that he had access to in order to run his business, his private business. He made a lot of money doing it. In fact, he was in with another guy, and that case ended up coming to us, and we did an investigation, and the commission ended up ordering that he repay $62,000, which represented his use and some of the revenue and the money that he made as a result of running his business using the actual PennDOT equipment. So these can take all kinds of different forms.
And then sort of the last little chunk that I'm going to talk about is gifts, travel, lodging, and hospitality. So this sort of goes into the idea that we can't receive anything additional to do our job. So to come here and do this presentation today, we can't accept any kind of additional compensation. This is part of our jobs. This is what the taxpayers are paying us to do, is to go around and talk about the Ethics Act in addition to other things. In sort of contrast to this, if I wanted to go somewhere and give a little talk on Taylor Swift and everything that she does, I could accept compensation for that because that's separate from what's included within my job here at the Ethics Commission. But we can't accept anything like gifts, even travel, things just being paid for in addition to what we already receive as compensation. That is pretty clearly laid out that we wouldn't be able to do that.
Yeah. And that's one of the honorarium provision that deals with sort of double dipping. You can't get double paid for the work that you do working for the state or working for a governmental entity. The Ethics Act, it does require, if you are to receive a gift, travel, lodging, or hospitality, you might have to disclose it on your statement of financial interest too. And we'll talk about that a little bit. The problem with these types of things come in when you start to receive them, like just a gift. It's not, not for doing double dipping with the work you do, but you're just receiving gifts from someone out in the community or somebody that's trying to get work from you or trying to basically sway your judgment by giving you something. And in return, there's this expectation, or at least this appearance, that you're going to do something to benefit the giver. That's when the problems come in. And I want to talk a little bit about that in the context of a story. If you've been to my presentations, you may have already heard this story. Does anybody know what this is? Has anyone ever been to this spot in Pennsylvania? All right. So, Joe says it's the Kinswood Bridge. He's right. So this bridge, this is a massive bridge, railroad bridge, located in McKean County, Pennsylvania. It has been there since like the 1880s. I think it was originally built then. When I grew up nearby this bridge, and we used to go up and we would picnic. We'd walk across it and then hike back down through the valley and do like a picnic or whatever. It's just a really cool giant bridge. The picture doesn't do it justice. It actually was considered one of the 8 engineering wonders of the world at one point. Well, this bridge, it was very old, and it started to deteriorate. In the 1990s, maybe even sooner than that, they shut it down to train traffic. And so it could just be used by pedestrians, but it still wasn't really all that structurally sound. And so it was DCNR, Department of Conservation and Natural Resources. It was within their sort of jurisdiction. And there was an employee from DCNR whose responsibility it was to oversee repair of this bridge and make it structurally sound. And so it really quickly became an emergency issue. And so they were, because it was an emergency, they were able to sort of go around some of the procurement rules and go out and direct buy things they needed in order to fix this bridge, including some supplies that they needed. And so the engineers that did the assessment on it said, you have to do all these things. And you also we're also recommending that you go buy this epoxy coating. And the epoxy coating was supposed to go over a lot of the rusted areas of the bridge. And that, plus a whole bunch of other things, was supposed to make this bridge structurally sound. So our public employee who was in charge of this, he went directly to a company to purchase the epoxy. And there was supposed to have a warranty on it. So they buy this epoxy, they send it out to the job site. The workers start putting the epoxy up on the bridge, and it's not sticking right. It's not adhering. And they keep sort of raising this issue to the employee at DCNR, and he's ignoring it. And then there was problems with provision of the warranty that was part of the purchase, and he's ignoring that. And the reason he was ignoring it was because at the time that they were trying to put this epoxy on the bridge to strengthen it, he had accepted an all expenses paid trip from the epoxy company. He went to England with his wife. And when they were there, they were supposed to tour the epoxy factory, but of course they never did. They instead did some sightseeing and enjoyed England. And as he's continuing to ignore these issues with the epoxy. And while he's in England, it just so happens that a giant tornado comes down through the valley and knocked down the bridge. Now, if the epoxy had stuck correctly and done what it was supposed to do, the bridge would have still fallen. It was a very, very large tornado that knocked down this bridge. However, it got elevated at that point. We found out that this had happened, conducted an investigation, and the commission found that he did not exercise the responsibilities of his position with DCNR, because he had received this transportation, lodging, and hospitality from the epoxy company. And so he failed to do what was a responsibility of his office, which was itself an ethics violation. So the commission found that he violated the conflict of interest provision. He had to pay back, I think, around $4,000, which was the value of the trip. But I like to talk about this case, not only because it's something that I saw growing up, but I think it's a cool case and really underscores how you can do something as a public official or fail to do something that's under your responsibility because you're receiving the gifts, transportation, lodging, and hospitality. So this is what the bridge looks like today. It's under construction, so if you go up now, you can't walk out. But if you go up when it's open, you'll see that there's this beautiful viewing and a glass floor that looks right down into the valley. It's very cool. So if you're looking for a road trip next summer, check to see that it's open. I've actually had people go up to the bridge as a result of this, telling the story at these presentations. So it's a very cool thing to see. So, yeah, don't accept gifts and then take action or inaction as a result of them. Okay, so what are you supposed to do if you have a conflict of interest? Or what are you supposed to advise your client to do if you believe that they have a conflict of interest as to a particular matter? This is super easy, and I don't understand why people can't figure it out. If you or your client has a conflict of interest under the Ethics Act, it's super easy, just abstain. And don't just abstain at the meeting, public meeting, or when there's official action to be taken, like in public. Abstain for everything. Don't lobby behind the scenes for what you want, or to advise your client not to lobby behind the scenes to get what they want. Completely stay away from it, because otherwise you're running the risk of us opening an investigation, getting a complaint. It's just not worth it. You just abstain. There's some additional requirements in the law. If you or your client is called on to actually vote on a matter over which they would have a conflict of interest, and that is, there's two other things they have to do. One, they have to publicly announce and disclose the nature of their interest at a public meeting. And then they also have to file a written memo with the person recording the meeting minutes laying out that conflict. So it's really important that you do this, or that you advise your client to do this. A lot of people say to us, wow, I had no idea that was required. This written memo was required. And I say, yeah, well, it's been in the law since 1998, at least. It's required in 1103J. So if you advise your client to do this, or if you do it yourself, if you have a conflict, it does a number of things. One, you complying with the law, but number two, it's protecting you or protecting your client, because I can't tell you how often we get investigations and cases where the meeting minutes are a mess. And it's really hard for us to tell, did they vote or didn't they vote? And if you have this written memorandum in place and it's part of the record of the meeting, it's crystal clear this person didn't vote or you didn't vote, and it's just a different conversation. So please pass this information along. We have a template that we're happy to share with anybody. People ask for it quite often. They say, can we see it? We'll send it to them, and then they can sort of like fill it in, and it hits all the requirements of this section of the law requiring this public disclosure. But there's no necessary form. Just disclose it in a written memo and protect yourself or your client. Okay. Another section of the law that a lot of state workers, I think, may be familiar with, but maybe not so much on the local level, is this revolving door. This is 1103 G of the Ethics Act. And so this actually only comes into place when a public official or public employee leaves their public employment. This does not apply to like a typical municipal solicitor position. This applies to people who are actually public officials or public employees. What it says is no former, so they're gone, it's when after you go, no former public official or public employee shall represent a person, and a person can be yourself or it can be another entity, for promised or actual compensation before their former governmental body for 1 year after leaving. So somebody can leave their public position and they can go work wherever they want to work. But within that 1 year, they're not permitted to come back and make personal appearances before their former governmental body. And I think the idea behind this is to prevent sort of that preferential treatment that people have because of those connections that they used to have before their former governmental body. We're seeing more and more situations as well, especially at the state level, where people, and it seems like it's engineers, but people who are leaving these state agencies, they're engineers for state agencies, although it could really be any position, and they get hired by a private consulting company. These private consulting companies are requiring them, as a condition of hiring, to come to the State Ethics Commission and request an advice about how this 1103G impacts them so that they sort of cover their bases. So I want you to know about this. If you have a client that's leaving, or if you are serving in a public official or public employee capacity, know that this exists. Please do not run afoul of it. One other fact pattern that we've been seeing lately that I want to mention, we see situations where we have someone working at a municipal level, say they're a municipal manager, for example, they retire and come back the next day as the municipal doing the same exact work, except as a consultant. That could be a violation of the 1103G revolving door provision. Even if they're just kind of rolling right over from doing the same work as an employee into a consultant role, that could violate this. So if that's you, or if you have a client that's doing it, please reach out to us for some guidance. All right. I want to talk a little bit about our advice and opinion process. So this is a really important section of this presentation for you guys. This is a really amazing tool. If you run into a situation where you're not sure what you need to do, you're not sure if something is going to be an ethics violation, or maybe even if it's just a hot issue in the municipality where you're serving, and you know that people are going to be they're going to be saying so-and-so is violating the Ethics Act or whatever, and it becomes a political issue, this is a really, really awesome opportunity for you guys to get advice about how to handle a particular situation, and maybe even give your client a little bit of clearance. So let me tell you a little bit about what these are. So the Commission by statute provides advice and guidance to those regarding the duties of those who are subject to the Ethics Act. This advice and guidance is in the form of either an advice of counsel, those are issued by our chief counsel, or an opinion of the Commission. So an opinion of the commission is sort of like a super advice. Basically, somebody writes in, it's either a novel issue that they're asking about, or it maybe is going to have a wide impact. Our chief counsel can elevate that to our commission, and then our commission of 7 commissioners, they'll be the ones to issue the actual opinion. They're almost identical in regard to their legal impact. But we call them different things. Either way, if you request one of these, you're going to get something in writing that tells you or tells your client what you're allowed to do or not allowed to do. A couple of caveats. You're not allowed to request an advice on behalf of somebody else unless they've authorized you to do it. So we could see this in a situation where, say there's a municipal meeting, the 2 people on the board hate each other, and one is throwing around, they're violating the Ethics Act. I want to write in and find out if the other board member is violating the Ethics Act. We will not answer that. You can only be requesting them on your own behalf, or somebody that you've authorized to request on your behalf. There's also some instances where an employer can ask on behalf of their employee, but those are limited. So don't rely on those without taking a look at the law and maybe having a conversation with our legal division. So another caveat with these, they have to be prospective in nature. So for example, if something happened 6 months ago, you voted or you took action or your client took action to award a grant to their wife's nonprofit organization. You can't write into us and say, hey, was that okay? Because that's not asking for advice. That's actually a confession. And then we're going down a whole nother process, which is our investigative process. One other thing about advice is that I think is really nice, a really nice tool, is that you can write in and ask that they remain confidential. We post all of our decisions, all of our advices and opinions that are issued by the commission on our website. But if you want to ask a question and keep the identity of the folks confidential, of yourself or whoever you're asking on behalf of, you can just say that when you ask for the advice. And what you'll actually get is 2 versions. You'll get one that's fully unredacted, and then one that has like names changed and stuff, so nobody can tell that it's you or your client or whatever. And the only one that gets posted is the one that has those redactions. So you can keep that anonymity while still getting the protection that this offers. These do take about a month. So if you're looking to maybe ask for one, make sure you plan ahead. All right, so I'm going to roll into telling you a little bit about our investigations. So one of our major duties is conducting investigations into violations of the Ethics Act. We told you some stories about some of our cases. So like I said, we get a lot of complaints in every year. When we get them in, we do an initial review to make sure that they're alleging something that we can even look at. If they are, then we can open them into a preliminary inquiry where we poke around for 60 days and find out if there's reason to believe that the Ethics Act has been violated. If we find that, then we can open a full investigation. As part of our investigations, we're able to issue subpoenas, take sworn statements, we look at records, talk to people. We keep everything confidential with regard to the investigation, and we take that very seriously. We also keep the identity of complainants confidential. And again, we keep that we keep that responsibility we take it seriously. There was a court case called Stilt versus Quintino. It was a Third Circuit case where the complainant was talking about the fact that he had filed a complaint against someone. The Ethics Act statute prohibits public disclosure that someone filed a complaint. However, the Third Circuit said that specific statutory provision is violative of free speech rights, and so they struck it down. So a complainant, if somebody files a complaint with us, they're free to tell people that they filed a complaint with us, but we keep everything confidential with regard to an investigation. The only thing that's public is the final order of the commission. And again, we post those on our website. So if you ever want to go see if there's an order been issued against somebody or read through, want a little light reading, you can go on there and take a look at some of our orders. All right. So what can happen to somebody that violates the Ethics Act? We are an administrative body. So the only thing we can do is issue a public order. Those are on our website. We also send those out to the press. So sometimes these get picked up in news stories. I honestly feel like that's the biggest penalty, is when somebody is found in violation of the Ethics Act, is sort of that public shame that comes along with the public order. We can also the commission can also order restitution, and they can also impose treble penalties, which they do typically in more egregious situations. So financial penalties and sort of reputational penalties. However, the Ethics Act can be charged criminally. It can be a misdemeanor or felony, depending on the section violated, up to a $10,000 fine and up to 5 years in prison. We can and work with the Attorney General's office and DA's offices, and they can charge criminally if they feel that that's appropriate under the fact pattern. And then finally, we're going to wrap up this presentation by talking about statements of financial interest. If you fail to file your statement of financial interest or file a deficient one, you can be fined up to $250 per form. So I'm going to hand this over to Julie. She's going to tell you about some of those requirements for filing SFIs, and then I'm going to wrap it up, the presentation up with a story about how this can go wrong. So go ahead, Julie.
Okay. So just a little bit about who specifically has to file an SFI and sort of how you go about doing that. So the statement of financial interest, you can either get a paper form, or we have PDF versions, or a web-based form. So if you go to our website, which is ethics.pa.gov, you can see all three of those options, the PDF version that you can print, or the website that you can go to. If you go to the website version, it's really nice because it doesn't let you skip any of the boxes. So that's a good way to sort of avoid being deficient kind of in a simple way. You still have to fill out the information correctly, but at least you won't skip anything. And then the web-based form will also automatically get filed with us. So that takes care of sort of one of the main like filing requirements. In terms of filing, I know based on sort of who we saw was here today, there's a lot of employees that sort of fall under the executive branch, and you have, I guess, your own executive filing requirements that will sort of also file the SFI along with it. I don't know, Mary, if you want to try to explain that a little bit better.
Yeah.
But
Most of the people that work for the executive branch, maybe all of them, file using Office of Administration's online filing program. It's called like Financial Disclosures or something, and that like auto populates information in the SFI and the Governor's Code of Conduct form, and then auto sort of files it for you. I do think those actually go through an internal review at the agency, both by agency HR and legal, just for completeness. But for everybody else, you're going to be filing either the paper/PDF form, or the web-based form. One thing, just a point of clarity, the web-based form, if you use that form, you have to print it out. If you have to file locally, you're going to have to print it out and then file it like at your township or borough or whatever. But it does remind you when you're filling that out. I want to push for this web-based form. The biggest mistakes, the most frequent mistakes we see are missed sections. So this won't let you move forwards, as Julie mentioned. So if you can, use the web-based form. If you're not in the executive branch, use the web-based form. It'll help. It helps a lot, quite a bit. Okay.
So the something else that's sort of important to keep in mind is that both municipal solicitors, which is probably what's more applicable here, but municipal engineers are also required to file as well. There was actually a Commonwealth Court decision from a case that was CPC versus the State Ethics Commission that said even if a solicitor is retained by a municipality, so that would be as opposed to being employed by them, which would automatically make them the public official or public employee, they're not held to the conflict of interest and the other sort of behavioral type restraints. I think Mary had mentioned that earlier, but they're still subject to file their SFI. So even if you're not considered a public official or public employee as a solicitor for the purposes of everything else, you still have to file the statement of financial interest. Okay. And then just generally, how do you know if someone needs to file? So you'll look to the position descriptions and the duties of that position and compare it to the definitions of public official or public employee in our act. You can check with the governmental body that you fall under, but at the end of the day, it is ultimately your responsibility to know. So sometimes they'll have a list that they keep of generally who's required to file, but it is ultimately your responsibility to know or figure out if you yourself have to file the form. And then if you really need help, you can always contact us. Typically, we'll sort of give you a similar little piece of advice, but if it's a really complex situation, you can always take advantage of the advices that Mary talked about earlier. Sometimes when we have a situation that we sort of want the commission themselves to weigh in on, that's what we recommend if it's something a little bit different that we haven't seen before. Okay, and then filing deadlines. SFIs are due by May 1st. So you're reporting all of your financial information from the prior calendar year. So for this year, you'll file in 2025 regarding your financial information for 2024. And you do need to have a statement of financial interest on file for every year that you serve in the position, even if you were only there for a single day in that year. And then this also means that you need to file one for the year after you leave the position as well. And that's sort of where we get a lot of people, is that they don't realize they have to file for the year after, but you do. So we will come after you with our civil penalties if you're not filing for the year after. So make sure you just are set your little reminder to be able to do that for the year after you leave as well. And then where to file, this is going to depend on what your position is. So state level public officials are going to file with the Ethics Commission, and then each agency, board, commission, department, or body which you are employed or appointed. Other public officials are going to be with the governing authority of your respective subdivision. So that's whether you work for the township, municipal authority, a school board, things like that. Public employees are going to be with your employer or political subdivision. And then solicitors are going to be with the governing authority of each of the political subdivisions that you are solicitor for. So if you're a solicitor for 30 different subdivisions, then you might need to file you need to file your one statement at 30 different places. So you only need to fill out one form. And like we explained before, if you do the online one, it'll email you a copy of it. So all you have to do is print it, but you do need to file that form and list the information about each of those positions and each of those subdivisions or areas on your form, and then file locally as well. Okay. If you make a mistake or if you forget to file, don't panic. You can file an amended form. You just have to mark a box at the top that says it is amended. So if you file one and you do something incorrectly on it, it's totally fine. You just have to redo it and mark that it's an amended form. And then if you forget to file, you just need to file as soon as possible, but by May 1st is when we need those forms by. If you don't file, then we are able to impose a civil penalty of up to $250. And I had someone call in last week, not very happy and saying, "You're going to really charge me $250 for not filing this form." And it's yes, that's kind of the only way that we can get people to file, is that we have this penalty. It's silly. You don't want to have to pay that much money for just not filing a form. So please file.
All right, so I'm going to wrap up the presentation. This is our last substantive slide, and then we'll open it for comments or questions. I want to tell you a story about a case that we dealt with here. This is old. I worked at the Ethics Commission in 2008, and this I think is from 2008, 2009 timeframe. This is the case I handled when I was here. So Julie had mentioned that you have to file the year after you leave because you have to file for the prior calendar year. And so this particular situation came to our attention because this person was an employee, a public employee at the Pennsylvania Public Utility Commission, had left. And so she didn't file for, I think it says the 2009 calendar year, 2008 calendar year. It would have been due by May 1st, 2009. So don't know how it came to our attention. Sometimes we do random audits. Sometimes governmental bodies notify us if there's non-filers. Sometimes as part of an investigation, we'll grab all of them from that governmental body and look. But for some reason, however this happened, came to our attention, she was supposed to file and she didn't file. So we have a process where we send out a cure letter. We give people 20 days to fix it, and it's sent by U.S. first class mail, and it's kind of mean, and it says, first notice letter, it came to our attention, you were supposed to file, you didn't file, you have 20 days to fix it. If you do it, nothing will happen. She ignored it. So we sent out a second notice letter by certified mail, even though we don't have to, but we do it anyways. Sent it by certified mail. It was a little bit meaner. It said final notice, and it was maybe in bold or caps or something. You have to file, you have 20 days. If you fix it, nothing will happen. Well, she ignored it. So we filed what's called a petition for civil penalties before our commission, saying she was supposed to file, she didn't. Would you please impose this $250 civil penalty, which they did. They mailed her the order. She ignored the order. She now still didn't file her form, didn't pay. And so at that time, we were taking these cases for enforcement to Commonwealth Court. So we filed an enforcement petition over at Commonwealth Court. And Commonwealth Court said, yeah, the commission's order is good. You have to pay the fine. You have to file your form. Oh, and here's $370 in court costs. She ignored the Commonwealth Court's enforcement order. And so we went back to the Commonwealth Court and said, she ignored you, she ignored us. And they found her in contempt of court, issued a warrant for her arrest. And that finally shook this loose. She paid what was due. She filed the SFI. This is a copy of what she filed with us. When it came in, we laughed a little bit. It is not perfect. We went through it with a fine-tooth comb, but we decided that it met the requirements of the law in all material respects. And plus, we were just tired of dealing with it. So we accepted it for filing, but now we show this to the whole state. To show you what our process looks like. And if you hear from us, just fix it. It's not a big deal unless you ignore it. We're really looking for compliance with regards to these. So get it done right, get it done on time, and you will not have to hear from us. So questions, we are always trying to be a better resource to those who are subject to our jurisdiction. We want to help people understand what they need to do. We want to see you in questions and trainings and advices. We never want to see you as part of an investigation. So please, if you have a minute, if you can scan this QR code, takes you to a really, really short survey that could tell us how we're doing, give us feedback, tell us how we can be a better resource to you. Please do that for us. This is our phone number. You can call us. We have amazing staff here answering phone calls. We have a live person, should always be answering the phone when you call. We have 7 attorneys who are amazing, who can answer questions all the time for you. So please use us as a resource. That's why we're here. Does anyone have questions?
So we have one question. If you were promoted, which employee status did you put on the form? Attorney 3 to Attorney 4?
So I don't think we get quite into that level. Kayla, I don't think we care too much. The idea behind these forms are that we're trying to elevate, we're trying to make the public be able to see where a public official might have a conflict so that they can look and see that the actions a public official or public employer are taking are for the public good and not the private good. So I don't know that we would get down into that level, Attorney 3 or Attorney 4. If I were you, I would just put attorney on my statement of financial interest. If you're filling it out for yourself, I would just put attorney. I think when I was at DGS for many years, I think I just put assistant counsel or whatever, rather than getting down into that level of detail. Then you're covered either way.
Thank you. Any additional questions? I don't see any. So thank you, Mary and Julie, for this great presentation. And again, can you just remind us of the deadline? Because now after seeing what happens, we just don't want to miss it.
Yes, May 1st. So they're due May 1st. Your lunch is probably over, but if you have a half an hour in your day, get it done.
Perfect.
Yes.
Thank you so much. We really appreciate it. It was very educational.
One more thing, Alina, I want to just put a plug in. We are doing a co-presentation with the Office of Open Records on March 19th called a Good Government Symposium. It's open to the public. It's available to anyone that wants to come. It's free. If you go to our website, you can find a link to that, or I can drop it in the chat. I don't have it handy, but go to our website. It's there. Register, share it with anybody that you think might be interested. We already have over 400 people registered for it, which is thrilling, but like seriously, anybody that wants to come is welcome. We want to get this information out.
Perfect. Thank you so much. That's March 19.
Thank you.
Thank you.
Thank you again. And thank you everyone for attending.